I have a letter here from Miss Aisha Cooley Peoples that you may want to see. Have you seen it?
I can see it.
Have you seen it? Okay. Before we on Mr. Beasley. All right, I'm gonna try to project my voice. I'm wearing this hot mask today. Kind of abundance of caution. Someone next to me at church yesterday had a mask on and was coughing, and I didn't have a mask. So I feel fine, but out of an abundance of caution, I'm gonna wear this for a few days just to make sure that I'm okay and anybody else around is okay. So, all right, this is a matter of state of Ohio versus Nairobi, Niger, Peasley.
Sam Teasy.
Sam? Oh, well, I have Niger, Niger.
That's both.
Okay, okay, thank you. Case number B 2301165. Mr. Teasley is present in the courtroom with his attorney, Ms. Anna Mallory, Ms. Caitlin Group of the state of Ohio. This matter is set today for plea. I have in hand the plea documents, and is this how your client wishes to proceed today, Ms. Mallory?
Yes, sir.
All right, is that right, Mr. Teasley? All right. Are you the Nairobi Teasley named in this indictment? How old are you?
26.
How far did you go to school, Mr. Teasley?
I have some obstacles.
Okay, so you're able to read and write English language well. Mr. Teasley, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Mallory's signature here. Is this your signature here, sir, where it says signature of defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand you have a constitutional right to the trial, but when you sign this form, you're saying to the court, I understand that, but I'm waiving my right to the trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after you consulted with Ms. Mallory about your constitutional right to a trial? Do you have any questions about this form? All right, do you have any questions about your constitutional right to a trial? All right. Can you please stand this off for a second?
Oh,
It's just bothering me.
oh, sure, absolutely.
Yeah, thank you.
Oh, yeah.
I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering the Plea of Guilty. On the 3rd page of it, there are signatures. I recognize Ms. Rue's signature here, Ms. Mallory's signature here. Is this your signature here, sir, where it says signature of defendant? All right. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, he's going to plead guilty to count 2, weapons under disability, in exchange for state will dismiss count 1, CCW, and count 3, the misdemeanor weapons while incapacitated. There is a forfeiture specification on this. I do know that there is somebody else that alleges that that is their gun, but I think that's something they have to work out with the police precinct.
All right. Ms. Mallory, is all of that accurate?
It is.
All right. Is that your understanding too today, Mr. Teasley? All right. Sir, are you under the influence of any medications, alcohol, or drugs today? Do you now, or have you ever had to manage any type of mental health difficulties? Okay, so you have a prescription regimen that manages that condition? Okay, all right. And does it help well? Does it do a good job at managing it? Okay, all right. Are you presently under any type of probation or community control supervision in this or any other state?
EMU, he's not EMU for this court, but are you a municipal probation? Municipal court.
Okay, thank you. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything if you enter into this plea of guilty today, other than the dismissal of counts 1 and 3? Are you making this plea of your own free will? All right. Mr. Teasley, the state has indicated that it's expected that you will enter a guilty plea to count 2, having weapons following a disability, a felony of the 3rd degree. In exchange, the state is asking the court to dismiss the other 2 counts. Is that what you talked with Ms. Mallory about before this hearing today? Did you have an opportunity to review this 3-page plea form with your attorney before this hearing? And do you understand what it says?
Yes.
Do you have any questions about it? Did Ms. Mallory answer all of your questions about this plea form? Mr. Teasley, do you believe that you've had sufficient time to fully consult with Ms. Mallory before this hearing today about your entire case? And has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review and or discuss the evidence that the state has against you with Ms. Mallory?
Yes.
And Madam Prosecutor, will you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, the state has provided all under our continuing obligation.
All right. Ms. Mallory, do you acknowledge receipt the same?
Yes, Your Honor.
Mr. Teasley, are you satisfied with your attorney, Ms. Mallory?
Yes.
Now, sir, you understand the charge against you in count 2, having weapons while under disability, a felony of the 3rd degree. Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations in count 2 of the indictment? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and just proceed to sentence you immediately? Now, count 2 is a felony of the 3rd degree. And this being a felony of the 3rd degree, do you understand that you're facing up to 36 months in prison and up to a maximum fine of $10,000? And do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now? Well, if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand? Any questions so far? Mr. Teasley, since this is a felony of the 3rd degree, community control or probation is a possibility. Do you understand that I could place you on probation for anywhere up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control or a probationary sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 36 months that I previously discussed with you. Do you understand? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand? Any questions so far? Now, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I explained them? Do you have any questions whatsoever about your constitutional rights? Do you have any questions whatsoever about anything we discussed today? Knowing everything the court has discussed with you today, Mr. Teasley, do you still wish to enter a guilty plea to count 2, having weapon while under disability, felony in the 3rd degree? Counsel, is there anything further before I accept the plea?
Mayor.
May I hear a statement of facts?
Yes, Your Honor. Mr. Nairobi, Nigeria, Sam Tinsley, on or about the holiday of March 10, 2023, in Hamilton County, state of Ohio, knowingly acquired, had, carried, or used a firearm or dangerous ordinance with a firearm. At the time of the event, had been adjudicated to a child, the commission of offense that committed by an adult, who had been felony offense of violence to aggravated robbery. Hamilton County Juvenile Court under case number 15-2850X on June 10, 2015. At the time, the defendant had not been relieved from such disability from under operation of the law or legal process in violation of section 2923.13A2 of the Ohio Revised Code. And for the special act on that date, March 12, 2023, Mr. Tinsley possessed a Taurus 9mm firearm and the property was used in the commission of count 2 therein.
All right. Anything on the facts?
Nothing, no dispute with the facts. They stated, Your Honor, just want to point out that the officer was here last time, and everything in that letter that you received today is consistent with what the officer said. He had recognized his possession as not ownership, so we're hopeful to provide some mitigation, but he is guilty of the charge.
All right, thank you very much. Mr. Teasley, what is your plea? Did you hear what the prosecutor said? Is it true? What is your plea to count 2, having weapons while under disability and felony in 3rd degree? Let the record reflect that Mr. Nairobi Niger Sam Teasley was present in court with his attorney, Ms. Anna Mallory, and that Mr. Teasley was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Teasley understands the nature of his charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Nairobi Niger Sam Teasley guilty as to count 2, having weapons while under disability, a felony of the 3rd degree, in violation of Revised Code 2923.13, subsection A2. Counts 1 and 3 are dismissed at the state's request. Counsel, is there any reason why the sentence should not be entered today?
Only if the court believes that there is a need for a PSI and that it will assist the court. Otherwise, we are prepared to go forward.
All right, so what I know right now is that Mr. Teasley has a juvenile record, which is the cause of this having a mental disability, and then he said he's on municipal court probation?
Oh, she wants to terminate.
I see. Who is it?
The future judge, your own information.
Bertha Woods.
Oh, okay.
I think you meant she, probation officer.
Oh,
I was
okay.
planning
Oh,
on
okay.
terminating him.
Sure.
I think of this charge.
Oh, yeah, all right. Okay, I don't see any for PSI if you don't.
Okay, Prior, Mr. Teasley did not know he was under disability. This is the officer responding to a call between the two of them. he retrieved the gun from the car. He doesn't own it. She owns it, I think. He did not recognize that merely touching the gun would be a crime, but he had it on his hip when the officer arrived.
Oh, I see.
That's trying to get away from the situation.
I'm sorry?
I was trying to get away from the situation.
Oh, I see.
He is doing positive things. He is working on obtaining his CDL. He's getting counseling. He's now, as he told me, prescribed medicine. So the officer said he wasn't a problem when he came in, and it literally was. He had it on him, and he saw it as soon as he walked up.
All right. Thank you very much. State?
Your Honor, I don't know where Miss Mallory, I normally don't talk on police, but he's been a prior conviction for weapons under disability, back in 2020. Where he was, in 2020, he had been pled guilty to weapons under disability for the same underlying juvenile adjudication. So he knows he's under disability, he's well aware he's under disability. Alcohol played in this, that night, that's part of this mischarge. The weapons well intoxicated. And the police officer told the prior prosecutor that he has a repeat problem and that they make frequent runs to that residence for his alcohol-related issues.
I see. All right. Mr. Teasley, anything you want to say before I pass sentence? Do you have a drinking problem?
Yeah,
Think-
that's why
You think so?
I mean, yeah, certain things, I drink it, I'm not certain stuff.
Do you want to get some help with that?
Well, that's, but they see court clinic, that's what I'm going to counsel.
Oh, okay. How long you been in counseling for that?
I've been in court clinic about 2 or 3 months. She actually gave me a letter to get I think you are on the list, like on my updates, like all my tests for dating and stuff like that.
Yeah. Okay. Well, that's good. And what about you and your girlfriend?
I no longer talk to her anymore. I stay with my brother now, so to avoid that issue, because I can see that issue, like I wasn't received probation and then that she could get alcohol abuse, separate situation.
Okay. Well, that's good. You know, Mr. Peasley, there's a saying that life is about 10% of what happens to us and 90% of how we respond. So what that means is, I hear you saying, you know, this woman, ex-girlfriend was kind of part of the problem. And that may be the case, but it's how you respond. So you can meet someone else like her. You understand what I'm saying? It's all about how you respond. And so that's what I hope you're working on with Court Clinic, is your response. Drinking is a response, right? Getting angry is a response. So if you work on your responses, it doesn't matter who's around you. You know what I'm saying?
Like, what are you supposed to do when a person is, like, even the way they just keep, like, trying to engage in your life? Like, what
No, I understand. No, you're right. You're doing the right thing. You just get away. You're right. Absolutely. Okay. But what I'm trying to tell you is that people show you who they are pretty quickly. Sometimes we ignore it, right? It's like, they're a little crazy, but I think she's cute. So people will show you, or this person's negative, but he got something in common. So it's that but that gets people in trouble. We have to believe people when they show us who they are the first time. Okay? All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions the court determines to accomplish these purposes without imposing an unnecessary burden to state or local government resources. I have considered the need for incapacitation, deterrence, and rehabilitation and restitution. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I have also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Teasley, I hereby sentence you to a term of 18 months community control. That's probation. Where you'll be drug and alcohol tested, I want you to continue your mental health treatment, counseling.
I requested it myself.
That's good.
It's go on and get back. But that's too early.
Okay,
I suffer a lot of different stuff.
okay.
I know you see my background, watching my obstacle and mom and stuff like that.
Uh-huh.
So I did that myself.
Good. That's really positive. So 18 months community control, and costs will be imposed, no fine. If you violate the terms of community control, I will consider sentencing you to a term of 36 months in the Ohio Department of Corrections. You understand? All right. So right after court, you'll have to go to probation, get signed up to probation, and
What about being new?
well, you're going to probably ask you to take that off right now, right?
Yeah, it's a condition of bond, so around the east sentence we're requesting to be removed.
All right. Any state?
Your Honor, I would ask that remain, but I know it's a condition on it, so.
All right, thank you. EMD will be terminated, and so go over to probation after court. All right, you have anything else, counsel?
With him now.
All right, state,
No, Your Honor.
you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. I wish you well, Mr. Teasley. All right. We'll send over the paperwork now to terminate the EMD.
Thank you.
All right. Uh-huh. Okay, this is Baltimore.
Yeah, probation violation.
Okay.
Then they'll have to change the assignment.
All right, this is the matter of State of Ohio versus Casey Baltimore, case number B21000156. Mr. Baltimore is present in the courtroom with his attorney. Mr. Baker, Greg Baker, and this paper group of the state of Ohio. This matter is on for a post-conviction warrant return on a community control sanction violation. Mr. Baker, have you received a copy of the violation report?
I have.
All right, counsel, have you?
Yes, Your Honor.
All right. And, does your client wish to have a probable cause hearing, Mr. Baker?
No, no.
All right, probable cause waived. May I hear statement of facts?
Yes, Your Honor, Casey Baltimore, after being convicted of carrying a concealed weapon, felony with 4th degree and weapons under disability, felony with a 3rd degree, on 7/22/2021, was placed on community control. On 8/23/2021 for 2 years. He violated Rule 2. He was indicted on a felony under case number B23-02302. That is set for, I believe, a DST setting on Friday of this week. And Your Honor, he failed to make adequate payments in order to earn court costs. He only is paid $143 as of this report. I believe he owes something in the neighborhood of $800 worth of tuition. He paid only $143. He was supposed to meet Rule 11, which he was supposed to have a special condition being enforced by the ISP unit, obtain a GED or maintain employment. He failed to enter and or complete a GED program, and based on that, Your Honor, a order was placed on him and a warrant was issued.
All right, thank you very much. What's the plea, Mr. Baker?
Judge, the plea is going to be not guilty. Based on the Rule 2 evaluation, Mr. Baltimore denies that allegation. We would not dispute factually the other 2 violations for the speaking mitigation at the appropriate time. Based on one of the violations being a matter of he denies the plea as a whole is not guilty.
Okay,
There is a pending case.
yes, I see that. All right, so you want to set this on over for probation hearing along with the new case to see, is that what you want to do?
That's what I would request Judge, to keep them together at this point. I don't know what the state wishes to proceed on probation violation first, but then even on Fridays, we would like this to be set.
All right, let's put these together. Let's put this on for probation violation. And so when do you think this, the DSC will?
The DSC is Friday the 16th.
Okay, so then when will this be on?
We can continue this to Friday and then just move them on.
Or you can put it up, just move this to the next day that you would put DSC.
The DSC is this Friday.
I know, but after DSC is a pretrial, right? Set this on the pretrial date, you can say. Set this on the pretrial date that you would set the DSC case on after Friday. Because we don't, there's no need to put this on Friday, because we're not doing anything on it.
Yeah, you just need to say
What's going on, Mr. Baltimore?
I'm just really very good because this is our boss and we.
I understand.
Boss, like I was doing what I.
Okay, don't say, I know you're frustrated, don't say anything, because I don't know where you're saying, what you're saying right now. I will note that this, the probation officer says that he finds the facts of this new felony case bizarre.
I don't disagree with that.
As Mr. Baltimore was with the victim for the last several days until she called the cops on him and stated that he had a burglary warrant sitting from the incident 5 days prior. And, they said that the victim was found sleeping in the victim's bed on the morning of 5/18, and he did kind of act a felony burglary warrant and was arrested. The officer assumed that the charge would be ignored, but he was indicted. So even the probation officer finds this case to be a little fishy.
I do not disagree with that. But,
July sixth.
July sixth,
that's for pretrial and probation violation.
correct. And that would also be if the DSC would, move on to that date too, July sixth, 9:00. All right, what do you want to say about his bond?
Judge Esteban, the court does have in front of it the assessment of the probation officer. I can tell the court that the address in question is an address associated with Mr. Baltimore through prior paperwork, albeit not the paperwork filed by the police. In this case, his address has matched the address of the location. He was in fact arrested there several days after the burglary allegation was filed. Again, not to try the case this morning, but certainly it's odd that he would be arrested at the location where a supposed burglary happened. Obviously, the defense says he was there all along, really. But that's a trial issue. Nonetheless, Judge, as far as probation is concerned, he was compliant with probation for the most part. He did not go into a GD program. He had been working with Roosters Healthy. That's the reason he was not able to do that at that point. Other than that, he was doing well. I believe he was even reduced to a level of supervision from neighborhood supervision to general supervision. Sometime before this, the basis of the violation is charged. He had not able to respond to that. I did intend to file a motion to respond on that case. But for today, I want to ask the court to set a reasonable bond on the probation violation based on the fact that he's innocent, proven guilty on the new charge, and his violation is the minimum of the violation.
State,
Judge, I just know there's been discussion on the record about about the circumstances of burglary, but he is on probation in this court. He did pick up an F2 burglary, which has been indicted, and he also did not comply with certain rules of probation, so he asked for a bond, which would be consistent with the facts that picked up a new felony while on probation.
all right, thank you very much. So this, this is a bizarre situation, but, it has to go through the process. With regard to the probation violation, I'm gonna give him an OR bond. And then let the other case, go through the process as it needs to, okay?
Thank you, Your Honor.
Thank you.
Is Friday vacated for both, for the DSC?
No, DSC is on Friday.
Thank you.
Thank you for the new case. Thank you. Ms. Toby? Yes. What do you have?
Mr. Fan,
Okay.
I have a plea.
So at least you got a chance to get out there. Well, we're sorry.
Thank you, Ms. Wendy Brooks. Thank you.
I give to you how much you for.
I have it.
Judge, I just didn't get a chance to look
Okay.
at it before we're just allowed to courtroom.
Okay.
Thank you so much. Thank you, Your Honor.
Okay. And, I don't think we have signed. Oh, is your signature?
No.
My signature.
Oh, okay, okay.
Thank you, Judge.
Thank you. Is there a forfeiture on this?
Yes, Your Honor, but I believe it was on the other co-defendant's case.
Okay,
It says Mr. Giovanni possessed a,
so now it's,
no.
We're also forfeiting, I just didn't put it on because you could second.
oh, got it.
I don't think anybody's particularly interested in putting this Your Honor.
Okay. This is the matter of State of Ohio versus Anton Fant, case number B 2205882A. Mr. Fant is present in the courtroom with, Ms. Amanda Toki, and, for Mr. Lewis, and, Ms. Caitlin Booth of the State of Ohio. This matter is set for jury trial today, but it's my understanding the parties have reached an agreement, and, I've been here plea documents. Ms. Toki, is this how your client wishes to proceed?
Yes, Your Honor, my understanding is they've offered an M1 CCW on count 2, and we'll discuss count 3, and they've signed up.
That's correct, and he is not named an count in one of the indictments, so he will not be dealing with that.
Okay, thank you very much. Is this how you want to proceed today, Mr. Fant? All right. I forgot how annoying these masks are.
Yep.
They're just, oh.
It's okay. I
Yeah.
remember I used to double mask on the way too. So I remember when I was real, I used to double mask. I can't even picture.
Oh, I'm just wearing this on out of precaution today because somebody in my church was sitting next to me yesterday, coughing with a mask. I couldn't take the mask off and cough.
I
I'm
get
like,
that.
cough in the mask, don't take it off and cough. And I didn't have masks, nobody around us had a mask, so I was like, so I thought I would wear it for a couple of days just out of precaution. But it's just,
It's like we learned nothing with us.
yeah. All right. Mr. Fant, is this how you want to proceed today? All right. Are you the Anton Fant named in this indictment? Mr. Fant, how old are you? And how far did you go in school? Yeah, how far did you go in school?
He's in college.
Oh, you're in college now?
I'm in college now.
So you graduated high school, you're in college now?
Yes, ma'am.
Oh, okay. What college do you attend?
Universities, hour away from Louisville.
Oh, okay. And you're going to be a rising senior or a rising junior?
This upcoming season.
All right. So you're able to read and write English language well. And, Mr. Fant, are you a U.S. citizen? Have you ever served in the military? All right. You'll have to answer out, so this, lady can take everything you say down, okay? All right. I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize, Ms. Tolke's signature there. Is this your signature here, Ruth, as defendant? This is an acknowledgement by you that you understand your constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving my right. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with Ms. Tolke about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 2-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty, Reduction to Misdemeanor. On the second page, there are signatures. I recognize Ms. Brew's signature here, who's a prosecutor. Recognize Ms. Tolke's signature here, right here. Is this your signature? All right. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, as you heard previously, state's going to dismiss count 3 of this indictment for plea of guilty to CCW and misdemeanor of the first degree.
All right, thank you very much. Is that accurate, counsel?
Yes, Your Honor.
Is that your understanding too, Mr. Fan? All right. Mr. Fan, are you under the influence of any medications, alcohol, or drugs today? Do you now or have you ever had to manage any type of mental health difficulties?
Judge, before we go to, he might be a little tired, he had a child born yesterday.
Oh.
Baby shower yesterday, I'm sorry.
The baby,
He's due, baby showers yesterday.
I see. Okay. Well, you're not too tired to understand and know what you're doing today, right? Okay. Do you understand? All right. Are you presently under any type of probation or community control supervision in this or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all other than the dismissal of count 3 if you enter into this guilty plea today? Are you making this plea of your own free will? Now, the state has indicated that this is a multiple count indictment, but you were named in only 2 counts, count 2 and 3. Count 2, the state is asking to reduce that from a felony of the 4th degree to a misdemeanor of the 1st degree. Is that what you talked with Ms. Tolkey about before this hearing today? Did you have an opportunity to review this 2-page plea form with Ms. Tolkey before this hearing? Do you understand what it says? Do you have any questions about it? Did Ms. Tolkey answer all of your questions? Now, Mr. Fant, have you had enough time to sufficiently consult with Ms. Tolkey about your entire case before this hearing today? Ms. Tolkey and Mr. Lewis. Have your lawyers answered all of your questions to your satisfaction? Have you had an opportunity to review or discuss with your lawyers the evidence that the state has against you? Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
Yes, sir, we provided all discovery to my knowledge.
All right. Ms. Tolkey, you acknowledge you see the same? All right. Mr. Fant, are you satisfied with your attorney, Ms. Tolkey? And Mr. Lewis? All right. Now, do you understand this charge against you, carrying a concealed weapon, a misdemeanor of the 1st degree? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that count of the indictment that's been reduced to a misdemeanor? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being a misdemeanor of the 1st degree, do you understand that you're facing up to 180 days in jail and up to a maximum fine of $1,000? Since this is a misdemeanor of the 1st degree, do you understand that community control or probation is also a possibility? And that the court could place you on probation for up to 5 years instead of sending you to prison or sending you to jail? All right. And do you understand that if you are placed on a probationary sentence, you'll have to abide by all probationary conditions as established by this court? And if I place you on community control or probation and you violate those conditions, you'll be brought back before me for a more restrictive sanction, which could include the imposition of a whole host of penalties. But the most severe penalty could be the imposition of prison time or jail time up to 180 days. Do you understand? You have any questions? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that? Mr. Fant, when you plead guilty, you give up some very important constitutional rights. I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? You understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? You understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, Do you understand that at trial, you could not be forced to testify against yourself? Do you understand you could be twice as I explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we discussed today? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights? Knowing everything the court has discussed with you, do you still wish to enter a guilty plea to the reduced charge of carrying a concealed weapon, a misdemeanor of the first degree, count 2? Knowing everything that we discussed today, and I know we've talked about a lot, do you still wish to go forward and plead guilty to the reduced charge of carrying a concealed weapon, a misdemeanor of the first degree? All right. Counsel, is there anything further before I accept the plea? May I hear a statement of facts?
Your Honor, Anton Fan, on or about the 12th day of December 2022, Hamilton County, State of Ohio, knowingly carried or had concealed on his person or concealed ready in a handgun other than a dangerous ordinance. In violation. Section 2923.12A1 of the Ohio.
All right, anything on the facts? All right, you heard the prosecutor said you did, Mr. Fan? Did you hear what she said you did? Were you listening to her? All right, is it true? All right. What is your plea to count 2? Carrying a concealed weapon, a misdemeanor of the first degree. What's your plea? Let the record reflect that Mr. Anton Fant was present in court with his attorney, Ms. Amanda Tolkien, and that Mr. Fant was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Fant understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Anton Fant guilty as to count 2. Carrying a concealed weapon, a misdemeanor of the first degree, in violation of Revised Code 2923.12, subsection A2. Count 3 is dismissed at the state's request. Is there any reason why sentence should not be entered today?
No, Judge, what were you thinking?
All right, who would like to say on behalf of Mr. Fant?
On behalf of Mr. Fant, Judge, as you heard, he's a rising junior in college. He's expecting a child. I apologize for miscommunication earlier. But he's also employed as well with 2 men under track, and he's been doing very, very well. We appreciate the state's consideration as to the plea, and while it is a misdemeanor, we have no objection to forfeiting the firearm.
All right, thank you very much.
He also runs his own business.
Oh, what kind of business? A clothing line? Oh, okay, what do you kind of clothes you sell?
So, pretty much everything.
Like what?
Hoodies,
Hoodies?
sets, summer set, 2-piece with a female swimsuit.
Okay, is that who you got on yours?
It's actually one of my boys that graduated with
Oh, I see. Well, you're supposed to always wear your stuff
Sure.
because it advertises, right? Right now, you're advertising your friend's stuff.
He didn't want to help me start my friends, so I gotta show support with him.
Okay. Great. State?
Your Honor, we'll go forward to the court. It was his age that disqualified him from a CCW more than anything else.
Oh, I see. All right. All right, anything you'd like to say, Mr. Fant, before I pass sentence? All right, what are you studying? Marketing. Oh, so you should be wearing your stuff. Right? All right, that's good. And you play football? What position? Oh, okay.
And Judge, as previously noted, that University he attends is an hour outside Louisville, so he does live in Kentucky most of the year. So
I see.
we're the Department of Community Control, we would either not reporting or maybe transferring to Kentucky.
Okay. Well, I do remember that during the pendency of this case, which has been about 6 months, he has been on a pretrial release. There was a time when he was on EMD, and he's not on EMD anymore, but he was on EMD for a while and, in school, and he never violated it. So I removed the EMD because he was in college and in school, and, he had no new charges and didn't fine, so I'm really happy to know that. All right, well, with the PSI being waived and the agreement to the gun forfeiture, I'm gonna, order you to pay court costs. There'll be no fine. I'm not gonna put you on probation, Mr. Fan. I just want you to go and finish college. So, will you do that? All right. All right, good luck, in college and good luck with your, business. All right. Oh, wait. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you with the cost to you. Do you understand? All right, thank you. Thank you. All right, who's next?
Your Honor, we can do Mr. Edwards.
Okay. Mr. Edwards.
Judge, I am Mr. Everett.
Okay,
Tom Reese, for the record. Good morning.
yes, hi, good morning.
Good morning, Judge.
This is the matter of State of Ohio versus Kyle Edward, case number B2301375, Mr. Raceback, for Mr. Edward, Ms. Brew, for State of Ohio, for pretrial. Counsel, what's the status right now?
Well, Judge, actually, this was a transfer from drug court, and I had filed a motion to reduce the fine while it was there. When it came down to you, Judge, I went ahead and filed a second motion to reduce fine. I thought that would be on today, contemporaneous with the pretrial. But Mr. Edward is not on that. So, but with that being said, Judge.
Mr. Edwards, will you?
These are right to Justice Center, Your Honor, they didn't bring him over.
They did?
No, I think he's bombed out.
Effort. When I checked,
Yeah, I had him as not in this.
well, that's probably not upstairs.
And it's probably not here to attend.
Yeah, I had him not in the Justice Center right now.
Yeah, he bombed out on June 2nd.
Well, with that being said, Judge, we have negotiated a plea this morning, which I had discussed with Mr. Everett, that was the way we wanted to resolve the case. We do have scheduled dates, Judge, so since he's out, I think our final pretrial conference is scheduled on,
July 6th.
and on that particular date, Judge, I would expect we'd resolve the case.
The only issue to say is he's not here, Your Honor, so how do we see his attendance on July the 6th? You can contact him.
Well, I have contact information, Judge, I'll make sure that I can do everything to reach him.
Okay, so this is what we'll do, because he's required to get the final pretrial anyway.
Right.
So we'll do that on July 6th, and if he doesn't show up, then we'll be a warrant.
I understand, Judge.
Okay, all right, thank you very much. I'm going to deny the motion to reduce bond as moved.
Or I can withdraw it, how you.
I'm going to answer these.
Thank you.
Okay,
Thank you.
thank you. All right, so we'll continue as already scheduled, and we'll deny the motion to reduce bond. All right, I know Mr. Boston has been sitting here for a while, but who is this?
Kyle Davis.
Mr. Davis, all right, we'll do Mr. Davis and we'll do Mr. Boston. Case number, this is the State of Ohio versus, Kyle Davis, case number B19011216. Mr. Davis is present in the courtroom with his attorney, Ms. Ann Mallory. This case agreed with the State of Ohio. This is on for a motion to mitigate, and, counsel, I read the motion, but it said that, the reasons for the motion will be revealed at the hearing. So would you like to say on behalf of Mr.?
Your Honor, I put that in the motion because I think that Mr. Davis can, better voice what his issues and concerns are. I think they're surrounding jail-based treatment. I think feels that his needs are not being met at that treatment, and he's hopeful that the court would consider something alternative, maybe Crossroads or Cat House, something. He's indicating he's absolutely not opposed to being in treatment, but he does have concerns that have been voiced to the court about the treatment that he's in
All right, where is he again?
at the jail.
Oh, yeah, he's at the Tyler House and then suspended, right?
Yes, Your Honor.
All right. And I, had Mr. Davis. All right, Mr. Davis was just sent there in April.
Yes,
Matter of fact, 2 months from ago to the day. So what do you want to say, Mr. Davis?
First, I want to thank you for giving me a chance at treatment again, and I greatly appreciate it. I really do. The only concern I have is my mental health isn't being taken care of. Like I got PTSD from my past, and there's no kind of treatment towards like my mental health. Like I've been there for 2 months now, and I started the MAC program just recently after 5 weeks of being there. And it took that long to be on MAC. And then like a week later is when they started me on my mental health medication, but I didn't get no type of counseling for address the whole reason why I use. Like I get high to cover up my past, dude. I'm not even addressing it.
All right. So right now, though, you have been placed on medication, right?
They're giving me the medication, but I'm not getting the counseling.
Now I understand. Is the medication helping though?
Not really. I mean, I still have the recurring nightmares. Like I barely sleep, and that's the whole reason why I get high is because of my past.
I see. Well, what's the medication for?
It's supposed to help me sleep and help me from being like nervous, and it's not nowhere near effective as if I had the counseling.
I see. So you're not saying that, the program's not working, it's just, that you just don't have the counseling to go with it.
The mental health counseling.
Yes.
I mean, the program's great. I'm not saying that it's a bad program. I appreciate you sending me to a treatment. But it's just the mental health side. They don't address mental health. And I'm not even asking to get out. Like, I don't want to get out. I want to go to a different treatment.
Well, what treatment do you want to go to?
If possible, Crossroads, even Cat House or Lemire, or even at that had mental health treatment. I mean, counseling. I'd even be fine with outpatient, like doing an outpatient treatment. Anyway.
Like I ordered you to adapt in January of 2022. Remember?
I do.
And
I stayed clean for some time when I got out of there. I worked aftercare through Brightview. I was reporting, and then I ended up, the sober living I was in, I made a mistake and backtracked.
Yeah. That's why we did a different program, we did the townhouse and it's extended. All right, well, it sounds like, you know, things are working except you're not getting counseling. So I'll just, check in the probation to see about the counseling portion of it. This Todd looks like he's his probation officer. Victoria. If you can have him just sit over here just a moment, I'm gonna call over there to Ms. Todd to see about that portion of it. I think he needs to stay where he is, just make sure that piece of it is happening. We'll get her on the line. In the meantime, we'll do Ms. Bostic. State of Ohio versus Clyde Bostic, case number B23011193. Mr. Brett Baker and Mr. Bostic are present in the courtroom, and the paper group of the state of Ohio. Mr. Baker, this is a pretrial, and we have a final pretrial conference on July 27th and a jury trial on August 13th. What's the status right now?
We'd like to maintain the trial date and maintain the pretrial date, so it's,
Okay. Is there outstanding discovery still?
Your Honor, he has everything, copies of everything I currently have. State needs to file formal, like he has all the actual physical things that the state has at this point.
Okay. All right. Well,
I believe the body on camera may be outstanding at this point.
I believe it is, yes.
it's still outstanding?
That's correct, Your Honor, which is not shocking.
Yeah. All right, can you make another request for, it looks like it's been 2 months,
That's,
normal?
4 to 6 is the standard.
Oh, okay,
4 if you're lucky, 6 if you're very unlucky.
okay. Mr. Baker, do you want another pre-trial, or do you want to just continue this as already scheduled to the end of July for the final pre-trial conference?
It's always scheduled,
Okay, so I'll note that Mr. Bostic was present today, and we'll continue, this is already scheduled for the final pretrial conference. If we're getting close to that final pretrial and you don't have the discovery of the UWC, then let Ms. Howard know, just advance this to deal with that, okay?
Yes, sir.
All right, thank you very much.
Thank you.
Anything else?
No.
Okay, Steve?
No, Your Honor.
Thank you. Is Ms. Todd available? We're gonna kind of call the probation chief, see that is, Mr. Tor,
Yes, Your Honor.
you wanna bring your client down?
Yes, please.
Okay. We'll wait, Mr. Magnuson, that's on him.
He wanted to talk to his client, Your Honor.
Okay.
Mr. Baker went off to watch something, he said he'd be back in about 15 minutes. Mr. Davis.
I'm sorry, what you said about Mr. Danny Davis?
So Mr. Baker, went off to watch a piece of video, he'll be back.
Oh, gotcha.
Your Honor, there is resolution. In this case, I have the number, if you'd like to write that down.
How much is it? How much?
It's $2,767 to, that we can Menards. The address is 2789 Cunningham Drive,
What's the status?
2789 Cunningham Drive.
Johnson.
No.
So what is it?
Jay, she said they don't do this right now. They don't do that.
I know that for people come out of jail on crossroads to address dual diagnosis because they don't have the ability to.
Okay, so we'll have to get an assessment first.
For crossroads. That's what I told them. I know, they don't have what we willing.
Ask them if they can do one.
She said you have to put it in.
All right, well, and we'll continue, we're back on the record, and Kyle Davis will continue this matter for a mental health assessment. And, it's 2 weeks of that time. For a mental health assessment,
My projected out date from, there is on July 17th, I believe. And that's when my counselor said that I'm supposed to be completing the program.
I have that your men's extended program is until, September 22nd.
I think that's 180 days, and then they mitigate them out after they finish the program.
Oh, and he's saying that he might be done early.
Yes,
That's the projected out date, like for my medication to come back to this.
Oh, I see.
And if I can, last time I seen you, you said that, I believe, I'm not right, I'm just saying. I think it's, you said that if I completed the program, you can terminate the relation. I'm not sure, I'm just trying to see if I'm correct.
Thank you. Did you want to kick it out a couple of weeks?
How much?
Couple of weeks?
How long do you need?
The person at the court clinic said that she needs the probation officer needs to do it for treatment services. She wasn't sure how long it would take, so she said she was going to go on to the death case.
The reason why I said that, John, is because I want to see if you can reinstate me, but me, where I'll go directly straight to mental health and do the assessment today and then go into Crossroads. That way, if possible. And that's my word. Like, I want that help.
You're not doing that out. I'm not releasing you.
I understand. I'm just making a suggestion, that's all. I just want to have the help that I need before.
All right, so this is an outstanding restitution. Probation doesn't have a problem if in fact, they're not opposed to me terminating him early in probation if I want to do that, if he does a civil agreement on restitution. So, we can go forward on this motion to mitigate. I can put him, in line for a mental health assessment, and he can go to Crossroads if he's accepted, but that's gonna take a while. Or he can, finish the program as he is doing successfully. Probation is not opposed to him terminating early, so I wouldn't, but he got to do a civil agreement for the restitution. So what do you want to do?
Your Honor, I'd like to enter a civil agreement and just, based on that he has started the program at Calvert House and the engagement was outdated on July 17th.
Is he, withdrawing his motion to mitigate?
Yes, Your Honor.
Is that what you want to do today, Mr. Davis? All right, oral motion to withdraw the motion to mitigate is granted. As long as you successfully complete the program you're in and there's a civil agreement for the restitution that you're supposed to pay, I don't have a problem terminating.
Is it okay if,
All right, All right, if there's nothing else, thank you very much.
And is it just file this with the court?
When he comes back in front of the court.
Oh, we're coming back, okay.
Do you want to set another day?
Well, I guess you should maybe do the motion to litigate on then.
And
When is your expected done date?
My projected updates on the April or July 7th.
All right,
I will, I am not, I'm out on vacation at that time. Is it possible, would it be possible to come on July 10th, knowing that he would have 7 more days to complete? That, I'm here, that's my last day in town before he gets out.
I see.
You know, I think the problem with mitigating out just on his exact out date is there is some transitional care they do with him to get him housing and all that sort of stuff up. So maybe it would be better to give him a week or two on the motion to mitigate. So
That's what I think.
That's
I'm
what
thinking the
they set up already. There's some motion setting that up. I got
I'm thinking the 24th.
in my pocket for,
How can we do that?
24th.
July.
July 24th, I'm available.
All right, July 24th. We'll keep the motion mitigate on, and, I want to grant the oral motion yet. So we'll just, keep it on to July 24th. All right, thank you.
All right, thank you.
So we're not doing the mental health assessment.
He would want to finish the program.
Okay.
So we not doing a mental health assessment? I mean, if I'm gonna do the,
Maybe it would be in his interest if there's gonna be aftercare, then at least they have
All right, let's
recommendations.
go ahead and do the mental health assessment and, continue this to 24th.
Thank you.
All right, thank you. I have a Reginald Jones, please. Mr. Jones. Reginald Jones.
Reginald Jones.
Uh-huh,
Thank you.
thank you.
Thanks for moving that date to the United States. I appreciate it.
Oh, no worries.
If you don't mind, here, I have from this 20 days to refugees.
Who is it?
Reginald Jones. All right, when we have to take
Yeah, also,
I need to leave some space.
23 days.
23, okay, thank you.
You're welcome.
We'll come to you in just a second. You want him to do a thanks trial. Okay. Yes.
We get Mr. Tucker's one.
You can be next in line.
Okay, thank you. And, so I had a jury waiver, or it was not going to get,
What'd you say?
I had a jury waiver.
So you're gonna bring, out there, mine. It's- I'm doing this.
Okay. So we asked. What is the case?
What else is going on here?
And you said,
And there's nothing that you can do.
And I'm not going to
Well,
I tried to talk him into that, he said, no, he wanted to get. He wants person to.
were you planning on planning? Yes.
Every Monday.
Oh, yes.
Absolutely.
Have a good day.
You too.
Thank you.
My understanding is pretty good. I just told him, this robbery, he will be served out money. Property or
No, I get it.
their influence that he takes the guys and he takes property. Like you can strip out the money, whether or not your guys says he dropped $22 or not, sharing your guys' debt, just take a lot of credence in his word about that as his money. You strip out the bare minimum of the money issue is why does he have the defense? Why does he have victims in his time? Of which he admits to taking now. Assault plus theft equal robbery.
Well.
Should. She targeted. Yes. Okay. Okay.
My next question is, we're probably going to be that's the no problem. Just FYI.
Okay. Mr. Cool, are you doing a plea hotel?
Yes.
Okay. You asking for PSI?
No.
No. Thank you.
Right.
Ms. Brewer,
Yes, ma'am.
we have towers. Pardon? We have no drugs.
We are going to look at either possible or instructing like something, I'm not going to open the video, we're going to try to get this done.
I don't want to.
Facilitate the.
Okay. I want to talk to Judge about something on the screen.
Because there's some where I do it.
Mr. Jones? Okay.
She's walking in the door.
is the matter of State of Ohio versus Reginald Jones, case number P23-00617. Mr. Jones is present in the courtroom with his attorney, Mr. Core, and his group of the State of Ohio. This matter is set today for pre-conviction habeas return, clear trial setting. But it's my understanding the parties have reached an agreement on resolution for this case. Is that accurate, Mr. Core?
Yes, Your Honor, I can be another completion of the charge.
All right, thank you very much. Is that accurate, Mr. Jones?
Yes.
Are you the Reginald Jones named in this indictment?
Yes.
Mr. Jones, how old are you?
I'm 41.
How far did you go to school, sir?
College 2 years.
All right, so you're able to read and write the English language well.
Yes, ma'am.
Mr. Jones, are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
Yes, ma'am.
Tell me what part of the armed forces,
Air Force.
and how are you discharged?
I made it to boot camp and then I got discharged.
I see. All right. Well, thank you for your service. Mr. Jones, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Core's signature here, but up here, is this your signature?
Yes, ma'am.
This is an acknowledgement by you that you understand your constitutional right to a trial. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with Mr. Core about your constitutional right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial?
No, ma'am.
I also have, Mr. Jones, a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Ms. Drew's signature here, Mr. Core's signature here, but right here, sir, where it says signature of defendant, is this your signature?
Yes,
Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, my understanding is gonna plea as charged, Your Honor, with regards to this offense.
All right, thank you very much. Is that your understanding today too, Mr. Jones?
Yes.
Mr. Jones, are you under the influence of any medications, alcohol, or drugs today? Do you now or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
Say that again.
Has anyone promised you anything if you plead guilty today?
No.
Are you making this plea of your own free will?
Yes.
Now, the state has indicated that it's expected that you're going to plead guilty as charged to the single count indictment theft, a felony of the 5th degree. Is that what you talked with Mr. Core about before this hearing today? Did you have an opportunity, sir, to review this 3-page plea form or discuss it with your lawyer before this hearing? Do you understand what it says? Do you have any questions about it? Did Mr. Core answer your questions about whatever questions you had about this plea form? Mr. Jones, do you believe you had sufficient time to consult with Mr. Core about your entire case before this hearing today?
Yes, ma'am.
Has he answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review and or discuss the evidence that the state has against you with Mr. Core before this hearing today? Have you had an opportunity to review the evidence that the state has, discovery, or discuss it with Mr. Clore before today's hearing? All right. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
The plea guilty is true.
Okay, and can you also, also put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, and any to your knowledge?
And I'll have provided everything, Your Honor.
All right, Mr. Clore, you acknowledge what you're saying?
Yes.
All right. Mr. Jones, are you satisfied with your attorney, Mr. Clore? Now, do you understand this charge against you, theft, a felony of the 5th degree? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being a felony of the 5th degree, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500? And do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? All right. Mr. Clore, you filled out this plea form correctly, but if you wouldn't mind in the PRC section, can you just put up to 2 years also? Sure. Thank you. I just want to make sure Mr. Jones understands his rights. All right, Mr. Jones, do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? All right, I see that Mr. Clore has now added that to the face of the plea form. Did you see him? And I saw him talking to you about that. All right. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Now, are you on post-release control? All right. Do you understand that if you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater? Do you understand that? All right. And that's only that apply to you. You understand?
Yes.
All right. Since this is a felony of the 5th degree, community control or probation is a possibility. Do you understand that I can place you on probation for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control or probationary sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control or probation and you violate the conditions, you'll be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be imposition of prison time up to 12 months that I previously discussed with you. Do you understand? All right. Are you okay, Mr. Jones?
Yes, man, I'm just processing everything so fast and so quick. I'm just thinking about everything you're saying. I'm thinking.
Okay.
Everything.
All right. Do you have any questions so far, though? If I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that?
Yes.
Now, when you plead guilty, you give up some very important constitutional rights in this case. I need to make sure that you understand that. Do you understand that you have a right, a constitutional right, to have a trial, either to the court or to a jury of 12 persons. Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Mr. Jones, do you understand each of these rights as I explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we've discussed today? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights in this case? So knowing everything that the court has discussed with you this morning, do you still wish to enter a guilty plea as charged to theft of felony of the fifth degree? Counsel, is there anything further before I accept the plea? May I hear a statement of facts?
Reginald Jones, on or about the 3rd day of February 2023, to on or about the 6th day of February 2023, Hamilton County, State of Ohio, for the purpose of depriving the owner of certain properties or services worth more than $1,000 or more but was less than $7,500, to wit, retail merchandise belonging to Menards, knowingly obtain or exert control over such property and services without the consent of the owner or person authorized to give consent. Your Honor, a number of things taken from Menards over a bunch of days. Restitution is $2,767.
All right, thank you very much. Anything on the facts, counsel? Mr. Jones, did you hear what the prosecutor said you did?
Oh, yes, ma'am.
Is it true?
That was probably one item that I took like four to five items on there. It's kind of added up a little bit higher than what I took. I don't know how you got that calculation. I know 4 of them was $400 a piece. That's like
That's $1,600.
And I took 2 more. It was like I think $7.99. I don't know what that adds up to, but it should be like 26, like 27, it should be like 20, 24, 25, something like that.
All right, but you admit that you did steal from Menards?
Yeah.
All right. What is your plea to count 1, theft, a felony of the 5th degree? All right. Let the record reflect that Mr. Reginald Jones was present in court with his attorney, William Court, and that Mr. Jones was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Jones understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Reginald Jones guilty as to count 1, theft, felony of the 5th degree, in violation of Revised Code 2913.02, subsection A1. Mr. Ford, is there any reason why sentence should not be entered today? All right, that's how I do the sentencing finding. You waiving the PSI? Okay. What would you like to say on behalf of Mr. Jones?
Your Honor, as the court has heard previously, my client is 41 years of age. He was honorably discharged from the United States Air Force. He's taking this matter very seriously. I talked to him at length. I know his background. He's taken some courses in 2 years of ITT Tech. I know he struggles with some back issues, but one of the jobs that he just recently spoke with was STEP roofing. It looks like the job is going to be available to him at $19 an hour, so long as he gets essentially clearance from his doctor because of the back issue. That's what he's hoping to be able to do. I understand there is a restitution amount. We spoke about that. He has 2 children, ages 3 and 6. Harris Ford, and, you know, at the time of those events, originally, he had expressed to me that he was experiencing homelessness issues at that time, created quite a hardship for him. Understands that this wasn't the route he should have taken, and he indicated to me as a move in his life in a positive direction. Being locked up has been an eye-opener for him, especially his 23 days of credits with farmers.
All right, thank you very much. State of Ohio.
You know, with regards to the restitution, so, it was on 2/4, keeping the grill valued at $749. Then on 2/4 again, he came back later in the afternoon, with another grill and another combo socket set that was valued at $419. Then he came back, on 2/6, and that's when he took, about $1,600 worth of merchandise by my math. It's 270, 670 is in the ballpark for that right number at that point.
All right, thank you very much. Has Marcy's Law been complied with in terms of speaking with the victim about this?
Your Honor, they've been appraised of the situation with regards to it's a business. I believe all they were seeking is restitution and a sale order.
All right, and so, do you see the need for, me to get a victim impact?
I do not see a need to get a victim impact, Your Honor.
All right. I'm gonna indicate in the record that, Marcy's Law has been complied with, since, the state has any contact with the victim requests the restitution sale order. Mr. Jones, is there anything you'd like to say, sir, before I pass sentence?
I just don't really say that being in jail changed my mind. I was going down the road. I'm not going down the road no more. I get the job, I pay the court for probation, and you know, my life, and do better. And I promise you won't see me there no more. And that's all.
All right, do you have stable housing now, Mr. Jones? You do?
Yes, ma'am.
Okay.
And I have a brand new car as well.
Oh, okay, so you have some stability.
Yes, ma'am. I can be seen on the run $2,600 off $50 and I bought a car.
I see. And, all right, so you have somewhere to stay, you have, transportation, and you have, access to a job.
Yes, ma'am.
All right, good. All right, the court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on Menards store and on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Jones, I hereby sentence you to a term of 1 year community control, you be ordered to stay away from the Menards store, all Menards stores. You shall pay restitution in the amount of $2,767 to Menards located at 2789 Cunningham Drive, Cincinnati, Ohio. Now, it's my hope that you are going to be able to pay this restitution in this year's probation time. But if you don't, I'm extending your probation. Okay, whatever you need to do. Pay Menards. Stay away from all Menards, okay? All right. Anything else, counsel?
No, Your Honor.
All right, you have a right to appeal your conviction is sensitive. Should you choose to do so, you must do so within 30 days. If you cannot afford the process to be appealed, an attorney will be appointed to help you at no cost to you. Do you understand? All right, and so you'll be released today, go to work, pay the restitution, stay out of trouble. Thank you. And report the probation as soon as you're released. That's all right, Mr. Fuller.
I got you.
Thank you. All right. This, Madam Prosecutor, do you all want to look at the video or something?
So we found a way to watch it, and I didn't do the live stream.
Okay.
So we're good for right now.
Okay,
I'm gonna talk to Mr. Baker, he's outside with his client.
sounds good.
Back over to the seat.
Okay, thank you.
Just gonna step out into the restroom.
All right, no worries. Mr. Magnus, we'll be ready on your case after the prosecutor comes back in, okay?
Who's my client get there, Your Honor?
Who's locked up, sorry, okay. Thank you.
Do I remember correctly that if we're gonna schedule a bench trial, you want the jury waiver?
Yes, sir.
We've got 16 judges in general division, 18 ways of doing so.
That's right. No, it's happening. What you say? It's, our current date. How would it be one? We can just, move it to the same week. Just that Wednesday.
Judge, could my victim turn on his cell phone very briefly so we can
Sure.
give you some contact information? Sure. Thank you.
You know what? Now I'm looking at this one. How long do you think this bench trial will be all day?
I don't think this is gonna be a long trial, I would guess 2 to 3 hours.
Oh,
I mean,
because it looks like I'm starting a civil trial that week and it's going on Tuesday. They don't want to start till Tuesday though. So I'm thinking I might have to read this on the bench trial on that day. So I can do it before the civil trial starts.
what I'm hoping it does is that we should do this sooner, perhaps the day that we're scheduled for final exam on the 29th of June.
You want to do it sooner than later?
That's-
Okay, let's see.
Yes, Mr. Signs up, his client.
I know,
How about the, Ms. Howard, if he wants to move it up,
I need 2 weeks on subpoenas.
okay?
I just suggested that the day we're scheduled for final retrial, the 29th.
No, I don't do it on Thursday. But, maybe about the fifth.
I'm gonna be away that week.
So you're way that week, oh, that would be perfect. So,
So honestly, it's either the 10th, which would only move this a week sooner, or the 26th.
How about the 28th, June 28th?
On a Wednesday, I'm having a,
We do all Wednesdays.
that one, you
28th works for me.
is that okay?
And I've got a jury waiver ready for us to sign.
Ten o'clock.
Sorry. Turn
It's not that.
Nice.
No, no.
Oh, it was Mr. That's fine. Okay, I think it's Mr. Davis' cell phone there.
People that need to find this, that need right handed. Non-jury trial, if you sign this, this says the understanding, you have a right to a jury trial. Give me a copy, choose your, like, just cross here without it. Right there. Do you want me to do this directly to you, Judge?
Yes, thank you. This is the matter of State of Ohio versus Jacob St. Tucker. Case number B 2301752. Mr. Tucker is present in the court along with his attorney, Mr. Richard Magnus. Ms. Caitlin Brewer, State of Ohio. This matter is set for a pretrial today. Mr. Magnus, do you have all the discovery?
As far as I can tell you,
All right, state.
Your Honor, I believe I have sent over everything that's in the state's possession, including paper, body camera, and surveillance, as well as Facebook posts and screenshots.
All right, we have all of that, you think, Mr. Magnus?
I believe so, Your Honor.
All right, thank you. All right, so this matter is set for a final pretrial, actually June 29th, and a jury trial on July 17th. But I have been handed a waiver of trial by jury, so that tells me that Mr. Tucker would like a bench trial. Is that accurate, counsel?
It is, Your Honor.
Is that accurate, Mr. Tucker? All right. Mr. Tucker, I have in my hand a single-page document entitled Waiver of Trial by Jury. I recognize Mr. Magnus's signature here and his bar number. Is this your signature here, sir? Can you see it from there? This is an acknowledgement that you understand you have a constitutional right to have your case tried to a jury. But when you sign this form, you're indicating, well, I understand that, but I don't want to have my case tried to a jury. I want my case tried to the judge, to the court. Is that your understanding of what you were doing when you signed this form? Did you sign this form after you consulted with Mr. Magnus about your right to have a jury trial? Do you have any questions about this form? All right. Do you have any questions about your constitutional right to have a trial to a jury? All right. So I will execute this, and I will set this matter now for a bench trial before me. And looks like we've already picked a date because Mr. Magnus has asked that your case be advanced from July 17th forward. So we do it sooner than later, okay? And so Ms. Howard, my bailiff selected a date that seems to work with both the state of Ohio and your attorney, which is June 28th. That's the last Wednesday of this month. All right, is that enough time, Ms. for you to get your subpoenas?
I believe it should be, Your Honor.
All right, and so, Mr. Magnus, I can vacate the trial date of July 17th, set this matter on for June 28th before me at 10 a.m. And we will still do the final pre-trial conference. Do you think that's necessary, Mr. Magnus?
Your Honor, I think this is probably as good a final pre-trial as we could have.
Okay, all right. So, I'll just say that, since the trial is going to be tried to the court, the only thing that I would want in advance, and in advance, I mean, it can be the morning of, are stipulations and any, motions in limine.
My only question for Mr. Magnus at this point, before I issue this, do I need to bring the gas station representative to authenticate that video?
I think we might probably agree that the pictures.
I'm sorry, could you, Mr. Magnus, I couldn't hear you. I didn't understand.
Mr. Tucker, are you okay with us accepting that the videos and pictures are real without making someone come in and testify to that? Your Honor, there's no problem there. We're not going to be disputing identity on this case at all. This is going to be, he's not going to walk out of here not guilty. We believe that this was an auto theft, not an auto robbery, and that's what we're going to be trying here.
I see, so a lesser included.
And then auto theft is not a lesser included.
Oh, I see. Oh, there's a completely something there.
Well, theft is a lesser included.
Yes.
But it's a misdemeanor theft, it's not theft of any felony level.
Oh, I see. Okay, well, that's what we'll be trying, right, to see what the facts shake out to be, okay? All right, so if there's nothing else, now, you know, if there's some nuance in the law or something like that, Mr. Magnus, that you want me to be aware of, and I know you're very good at understanding and pulling out the nuances of in the law. And so, if there's anything like that, please provide that to me before the case is tried, okay? All right.
I'm only around my client.
Sure.
We have Mr. Ronnie Davis.
There's nothing further, Your Honor. I don't expect any issues to come up pre-trial, but if they do, I will let the courtroom know.
All right, thank you very much. Mr. Tucker, do you have any questions? All right, we will see you on the last Wednesday of this month, which is about 2 weeks. Okay, thank you.
Thank you, Your Honor.
Mhm.
moving on fast.
Good day.
Have a good day, Judge.
Thank you, you too. You have one case left.
Mr. Baker is outside and I'll call his clients, you know, the agreement worked out on it.
All right, thank you very much.
He will be seeking, close up to seeking PSI and Bacon impact.
Okay.
As well.
Thank you. Okay, Martin, you do something? Hi. Congratulations. Good for you. And thank you for the card. All right, this is the matter of State of Ohio versus Danny Davis, case number B 2300111. Mr. Davis is present in the courtroom with his attorney, Mr. Rhett Baker, Ms. Caitlin Blue, of the State of Ohio. This matter is set for jury trial today, but it's my understanding that the parties have reached an agreement regarding how to resolve this matter, and I've been handed plea documents. Mr. Baker, is this how your plan wishes to proceed?
It is, Your Honor. We will be entering the plea to a reduced robbery felony of third degree. There will not be an agreement as to sentencing. We are going to request a pre-sentence investigation, followed by a court clinic as well. And sentencing will be up to the court. It's always up to the court, but this will be true of the police system.
All right, thank you very much. Is that accurate, State?
That's correct, Your Honor. Your Honor, the state is going to move to amend this down to a robbery felony of third degree in exchange for that plea of guilty. We are going to set this out for PSI and victim impact. It is going to be a true open plea. It's my understanding the defendant will push for probation. My victim, Mr. Marvin Matthews, is present in the courtroom this morning, has been consulted about this. He wishes prison time in this case, Your Honor, so that would be his request.
All right, thank you very much. All right, Mr. Davis, is it your intention and desire to go forward with a plea of guilty on your matter? All right, and I'll need you to come to the microphone so that the court reporter can hear you well. Are you the Danny Davis named in this indictment?
Yes, I am.
How old are you?
65.
Mr. Davis, how far did you go to school?
12th grade.
Did you graduate?
Yes, I did.
So you're able to read and write English language well?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Have you ever served in the military?
Yes, I am.
Mr. Davis, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom of this page, there are signatures. I recognize Mr. Baker's signature here. Is this your signature here, sir, right above where it says defendant? All right, can you see it from here? All right. This is an acknowledgement by you that you understand you have a constitutional right to have a trial, but when you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to a trial. I don't want to have a trial. Is that your understanding of what you're doing when you sign this form?
Yes, it is.
Did you sign this form after consulting with Mr. Baker about your constitutional right to a trial?
Yes, I did.
Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Ms. Gru's signature here, Mr. Baker's signature here, and up here, sir, where it says signature of defendant. Is that your signature? All right. Mr. Davis, are you under the influence of any medications, alcohol, or drugs today?
No, I'm not.
Do you now or have you ever had to manage any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this or any other state?
Judge, he's not electronic monitoring of the blind condition. He's not on community control, post-police control. So this plea would not affect any other matters.
All right, thank you very much. Mr. Davis, has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No.
Are you making this plea of your own free will?
Yes, I am.
Now, the state has indicated that it's expected that you will enter a guilty plea to a reduced charge of robbery, a felony of the 3rd degree. Is that what you talked with Mr. Baker about before this hearing?
Yes, I am.
Did you have an opportunity to review and read and go over this plea form with your lawyer before this hearing?
Yes, I did.
Do you understand what it says?
Yes, I did.
Do you have any questions about it?
No.
Did Mr. Baker answer all of your questions about it? Now, Mr. Davis, do you believe you've had enough time to fully consult with Mr. Baker about your entire case before this hearing today?
Yes, I am.
And has Mr. Baker answered all of your questions to your satisfaction?
Yes, he did.
Have you had an opportunity to review and or discuss the evidence, the discovery that the state has against you with Mr. Baker before this hearing today?
Yes, I did.
Madam Prosecutor, would you please put on the record whether or not whether or not the state has disclosed all discovery evidence, including any Brady material evidence that leads to your knowledge?
To my knowledge, all things have been provided.
All right. And Mr. Baker, do you acknowledge you see the same?
Yes, Your Honor.
Mr. Davis, are you satisfied with your attorney, Mr. Baker?
Yes, I am.
Now, sir, do you understand this charge against you, robbery, a felony of the 3rd degree?
I understand.
Okay. Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the indictment as reduced to robbery in the 3rd degree?
I understand.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, this being a felony of the 3rd degree, do you understand that you're facing up to a maximum fine of, up to 36 months in prison and up to a maximum fine of $10,000? Do you understand that if I sentence you to prison upon your release from prison, you could be on, well, let's see.
Shall.
Yep. This is a felony of 3rd degree. Is there a, this is about crime of violence?
Your Honor, it is a threat of violence.
Arrest of violence, yes, all right.
It's statutorily defined as offensive violence.
Yes, ma'am.
So,
All right, and so because it is defined as a offense of violence, that upon your release from prison, you shall be on post-release control up to 3 years, but not less than 1 year. Do you understand?
I understand.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Are you on post-release control, sir? Post-release control?
No.
All right. Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, in addition to being punished with a new felony offense, the sentencing court could add an additional consecutive 1-year prison term, or whatever time remains in your post-release control time, or whichever is greater. Do you understand? Since this is a felony of the 3rd degree, community control or probation is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control or probation and you violate the conditions, you will be brought back before me for a more restrictive sanction, which could include the imposition of a whole host of penalties, including the imposition of prison time up to 36 months. Do you understand? Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that? Do you have any questions at this time, Mr. Davis? When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer, Mr. Baker? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them? Do you have any questions whatsoever about your constitutional rights? Oh, yes, sorry, back in there.
I'm sorry.
Okay, thank you. Do you have any questions, sir?
No, I don't.
Do you understand that if you plead guilty, you are waiving all of these important constitutional rights? Knowing everything the court has discussed with you today, do you still wish to enter a guilty plea to the reduced charge of robbery at felony of 3rd degree?
Yes, please.
All right. Counsel, is there anything further before I accept the plea?
Nothing on the plea.
All right, thank you very much. Can I hear a statement of facts?
Yes, Your Honor. Your Honor, on or about the 3rd day of January 2023, Hamilton County, State of Ohio, Danny Davis, while in committing or attempting to commit a theft offense as defined in section 2913.01 of the Ohio Revised Code, to wit, knowingly obtained or attempted to obtain either United States currency and or personal property belonging to Marvin Matthews, and in the fleeing there immediately after, as amended, used or threatened immediate use of force against Mr. Marvin Matthews.
All right, thank you very much. Anything on the facts?
Nothing on the facts, so we're going to accept those two.
All right. Okay, Mr. Davis, go get your phone. It's not quite perfect yet. You just go get it. Mr. Davis, did you hear the prosecutor said you did?
Yes, sir.
Is it true?
Yes.
What is your plea to count 1, robbery, felony of the 3rd degree?
Guilty.
Let the record reflect that Mr. Danny Davis was present in court with his attorney, Mr. Rhett Baker, and that Mr. Davis was informed of all his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Davis understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Danny Davis guilty as to count 1, robbery, reduced to a felony of the 3rd degree in violation of revised code 2911.02 subsection A3. Is there any reason why sentence should not be entered today?
Your Honor, both parties are requesting a PSI that can impact on Mr. Baker's asking for a month without bill.
Okay. Mr. Baker, is that true?
That is correct, Your Honor. Mr. Davis indicated he did not have a history of mental health diagnosis. I believe that's correct. However, I've been informed that there have been some mental health issues undiagnosed. Certainly, there were no issues as to whether he was competent, and I did not believe insanity was liable, so we did not proceed that route. But we do believe that a court clinical evaluation for symptom purposes will be helpful to this court.
All right, we'll do it, because that's an advisability of treatment, right?
Yes.
All right. And I order a PSI and victim impact statement. All right, so let's set this matter for sentencing.
July 12th. What day, I'm sorry?
July 12th.
Out, that would be, my hope was, if we could go the following week, maybe Wednesday, I'm coming back Sunday night, I think 16th, but it's a little late, so I was thinking maybe the 19th, based on the flight issues and tomorrow, I'm going to say this.
Okay.
Did you say the 19th?
Yes, I'm good any other day, like that, maybe that week or the next week.
All right, looks like July 19th at 9 a.m. All right, and I know the victims here, because we're ordering a victim impact statement, so we're trying to give them more time.
Thank you.
All right, Mr. Davis is on EMT, correct?
Yes.
Okay,
I believe we had lowered the bond, Your Honor, so he could make bond on 417, but wasn't that can hear the trial, so he didn't lock up on the EMDs or anything.
oh, I see.
Yes.
Was this, the case that he was supposed to stay with his daughter and go to a nursing home?
Yes, and ultimately, unfortunately, he did spend a couple of weeks in jail before EMD worked out. He did get out, it took a couple of weeks, but he's now staying with his niece.
Oh, he's staying with his niece, okay. All right, excellent. Well, we will keep the EMD on until the 19th of July. All right, thank you very much. We'll see you then. You have to go to probation so that, you can, be interviewed very briefly and you're free to go.
Thank you so much.
All right, thank you. Thank you. Bye-bye. Have a good day. Be safe out there.
It's going to be the same.
I will see everybody tomorrow.
Thank you. You never meet tomorrow?
Oh, no, Wednesday.
Wednesday.
You schedule my brain.
Yes, ma'am.